Welcome to the Fearless Floyd Show. We'll begin in 2 minutes.
The commercialization of the courts.
Hello, welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd, and I appreciate you being here. And I published a couple of videos lately, and I'm trying to use a new format. And basically, the format is using a voiceover as well as images instead of me having to come on here and do it. It's time consuming to do that type of format, but I wanted to do it anyway, just to master it, learn a bit. I can't even talk. To learn a little bit more about editing videos, because that is a weakness of mine, not being able to edit videos. So I set upon myself to set a goal and to learn how to edit videos, and that's what I'm doing. So the first one I did was the commercialization of the courts, and that's what the title of this video is. And it turned out okay, but it had some missteps in it and some narration cues and punctuations that I wasn't aware of and didn't know until I had a final product of how that would play to the audience. So once I did it, and I've listened to both these videos I don't know how many times now to get the cadence, the rhythm, how it states things when I put in the difference between a colon, a semicolon, a comma, a dash, or if I have to write out the word dash so it can pick up and actually pronunciate it correctly in the video. So it's a work in progress for me. So for those of you who tuned in to the first commercialization of the court, this is a re-edit that I'm going to broadcast tonight. This is what I put together today, and it adds some more edits I added some new documents in there for you guys to look at, just to show the because when you tell somebody, oh, you're going to family court, yeah, that's a commercial proceeding. What the fuck are they talking about, right? So I lay it all out for you, black and white. It is what it is. Take it for however you want, and is what it is. For those of you over in the RV, of course, I did a Venezuelan update on the particular currency. And it's funny because usually I don't have the comments activated on my videos anymore. And it's just, if you want to comment, come over here and play live and comment all you want. But comments afterwards, I don't have time to go back and read them. Today, I was going back to get the video, and there were some comments. So I went and looked at the comments. And one of them, let me pull that up. See if the comments will come up. There they are. Oh no. He deleted it. Well, that sucks. Really? Come on, man. I really try to be humble sitting in this chair doing what I do with all the vast knowledge that I have attained, whether it's right, wrong, correct, incorrect, moral, immoral, whatever it is. Okay. It's my research. So what I wanted to show you in that post is, the guy brought up one of my past guests and all the bullshit that guy talked about. And I came up front and said, okay, if you really want to say that in front of God and everybody, knock yourself out, bro. But I'm over here laughing my ass off because that's the most ludicrous thing I think I've ever heard in my entire life. So covered that base. And then they beat me up, about, pushing trusts, pushing the class, pushing the books, call the books $500 books. Hey, listen, I don't know. As far as I know any place where you can go get 8 trusts, every form, every document, instrument, contract, letter, affidavit, declaration that you're going to need is in this book with examples, templates, instructions, the whole freaking 9 yards. Everything is in this book. You're not going to need anything else if you want to do a revocable, irrevocable, express, land, foreign, charitable remainder, or college education trust. Everything's in this book. Now, if you want a specific trust, it's over here in this book. Get this before that falls. That would be the specialty books, and this is obviously a proof copy. But this one has 17 different trusts plus the DNA addendum in it. Okay, this book, they're both the same price. And I spoke to Ann today because we need to schedule part 20 of our new 20-part series that we did. We've already got parts 1 through 19 in the can, along with the introductory. So if you haven't watched those, go over to my YouTube or Rumble and go check those out. So what we decided to do today is, we discussed that not everybody has $250. I get it. All right. I totally get it, because that's what a lot of people say. I just don't have the money, Floyd. Well, I think we solved that problem today, because generally I have the tailor-made trusts, $199, and that gets you just, your basic indoor for the trust, and you'll do a consultation, figure out exactly what trust you need, right? So what we decided to do is we're going to break these books up into individual trusts. for every trust that's in here, you can go to my website and you can go look at the tailor-made trust, but every one of those you'll be able to buy in a booklet. Okay. Not quite a book, but it probably could be with all the ancillary documents that go with operating a trust. So Anne is currently working on that as well as her topic, whatever topics that she's going to talk about in part 20. But there you go. That's something that's coming out. We're going to make it real affordable for everybody. And it would be like if you bought this book that didn't have these other 7 trusts in it, but had all the other documents in it. So for every trust that we have in these 2 books, you're going to be able to get the same thing, all the bang for the buck. Okay. It's all about, listen, I don't care where you get your trust. You just need to learn to operate in trust, because that way you can operate in public privately. And that's what everybody wants to do. Right. So I'm, like I always say, I'm working in the background with other people that are, on the forefront of all this stuff. So what we're working on now is getting the monetary aspect of operating in trust together, where we can exchange between us and see where we can get with that. Because I spoke to somebody today, they set up a Chase Bank account without an EIN. I was like, really? Well, it'd be nice if I could walk into Chase Bank now, because I'm banned from Chase Bank. Imagine that. So, yeah, when they run my credentials, they're like, oh, excuse me, officer, will you please escort this gentleman out of the bank immediately? Yeah, it sucks. So we have those books. They're available. We also have the classes, but I just wanted to let you guys know. But I did qualify my reply to Scott. I don't remember his last name, Scott something. And I just did this not even 20 minutes ago. He took it down that quick. That really sucks, because the last thing I put in there is, God bless him. But prior to that, do your own research. I'm not the one you want to take financial advice, medical advice, legal advice, or even friendly advice. Okay. I keep telling y'all guys that. I'm just searching for the truth. I don't care what it looks like, even if it's to my own detriment, and it has been on multiple occasions. It is what it is. If you don't fail, you're not trying. If you're not trying, you're not going to succeed. So regardless of who I've had on my show or what we've talked about or whatever, I try every day, harder and harder. I try to do my best. Better today than I did yesterday. Some days that's difficult. So is what it is. And I'm not messed up about how these books came to evolve, how I became a book publisher, an author, graphic artist. It just, all the accolades, achievements, goals that I set and reached doing these books with Anne LaFleur has just been, it's been an education and an experience that I wouldn't trade for anything. So I've had fun doing it. And whether you buy the books or not, or you go to somewhere else, you go to Scribd, or you hustle one from your friends, and I guarantee you, the trust templates that we had in our original revocable living trust class, people shared those, even though it's watermarked from top to bottom, side to side, copyright protected, all rights reserved. And they don't care. So, is what it is. So for those of you who did steal material and did put it out there, even though it's copyrighted, and put it in the public sphere, karma will come back. That's why I'm not too concerned with any of this. Never has I been in this for the money. So don't think for a minute I'm in it for the money, because I lose money every month doing this. Streaming software, I got to pay for this new voiceover software, website, mailbox, high-speed Wi-Fi. Before you know it, it's, you're like, damn, that's a tab for a hobby. right? Because I'm not doing it for a financial living. If I was, you would see my t-shirts all over our website. I'd be holding them up trying to sell t-shirts. Do you see me selling t-shirts? No. So, like I said, it's not about the money. It's always about the education, being prepared for the unknown, the unsuspected. Just like I did the video on the 2 killed. If you didn't catch that video, go check that out. That homeowner, okay, was supposed to be working with me that morning, and instead at 11 p.m. the night prior, 2 masked men with bulletproof vests and what looked like police credentials and announced themselves as police and beat on their door, and then it was a gunfight. And the 2 suspects were DOA on the scene with headshots, because you have to stay prepared. So go watch that video. That's all I try to do, is educate you and tell you never know what's around the corner. You never know when to be prepared for what. And just the night before that incident, they were talking about being prepared and sighting in their weapons to make sure that their sights were on time. The night before. Imagine that. Imagine that. Imagine getting that hindsight going, oh, wow, man, I'm glad I did that, right? There you go. Now, the commercialization of the courts, okay, this will be the banner for it. I run through here and I break everything down for you. This video is about 25 minutes. And then at the very end of it, of course, it has my outro tacked on. So I'll probably do this live and then take the videos down, and then I'll re-upload this video so you don't have to hear my bullshit. Or do both. I'm not tripping. So if you didn't catch my video on the Venezuelan update, and you either hold Venezuelan currency or any type of other foreign currency, and you may be thinking about investing in Venezuelan currency, probably want to watch this video and listen to it. Now, the first part of the video is a Fox News article with 2 guys that have contacts in Venezuela. And then the second one was from a journalist who wrote an article that's up to date, I think from the 21st, 4 days old, that talks about the monetary. And then I added on a narrative at the very end. And of course, I do all the caveats, talk about the return on your investment, that it may be tomorrow, next week, a year, a decade, or like without naming other currencies, you might just be waiting a generation or 2. So invest wisely and invest at your own risk. And of course, I'm not giving you any financial advice by any means. But part of it, he said I had no idea what I was talking about regarding the Venezuelan currency. And as far as I know, I don't know anybody who's put themselves out there to gain more knowledge about the Venezuelan currency than I have. And if there's somebody out there, post it in the comments below or over in the chat. I'd love to find out who they are. So putting together this video was fun, enlightening, entertaining, educational. I don't know. Let's see what the final product looks like, and you tell me. So without further ado, let's get the commercialization of the courts.
Scene 1. Walk into any courthouse in Texas or anywhere in America and the facade shouts what's inside. Criminal courts, civil courts, family courts, the massive towers of stone, a charade so secret until now. Inside, the machinery is the same, operating pursuant to civil rules using simple accounting and ledgers. Every so-called court is really a commercial court in disguise. What exactly are the massive towers of stone called courts? Like clowns in a circus, different venues for the same circus. Here in Texas, according to Dun & Bradstreet, these courts are legally called the Judiciary Courts of the State of Texas Incorporated and listed as a subsidiary of the State of Texas Incorporated, established by the people of Texas in 1845. Join me now on a journey as I explain every facet of these commercial proceedings, from the initial charge to the final discharge and everything in between of the commercializing of the courts as for-profit corporations, where the commodities such as assets and liabilities are really humans unwittingly caught up in one-sided adhesion contracts. Scene 2. The accusation equals presentment. It begins with suspicion. A police officer claims probable cause. A neighbor submits a sworn affidavit. On the surface, that's an accusation, but in commerce, it's a presentment. Commercial paper flowing forward, waiting for acceptance. Acceptance creates obligation. Obligation demands performance. A contract on the sly, signed, sealed, and delivered, all without your knowing hand. Scene 3. The warrant equals draft check. Next up is the ever-popular warrant. Search warrants, bench warrants, and arrest warrants. They call it an order, but in commerce it is a check, a draft, a security. The judge draws it seeking an endorser, which is you. A law enforcement officer presents the warrant. However, so far, neither you or the law enforcement officer know that it is really a financial transaction now gone seriously sideways. The pen really is mightier than the sword in this case. When the warrant fails to be legally endorsed to settle the matter, well, then someone has to pay up. That someone is you. Your body is the collateral, signed, executed, enforced, presentment, and acceptance. Here and above, there was no acceptance. The judge, his or her honor, have now been dishonored. When the warrant was presented, you didn't accept and endorse. It was then enforced to the fullest extent of the law. Scene 4. Police equals policy enforcers. Booking equals inventory. 5-0. 5-0's here. It's the popo. Everybody run. Run, everybody run. Knock knock knock. And the not-so-friendly policeman arrives. Policy enforcers. They don't just arrest. They process suspects into custody. How exactly? Custodianship, transportation, housing, fingerprinting, mugshots, classification, assignment, ledgered as a number in the storage facility commonly known as jail. That's chain of custody and in commerce, the chain of title. You've been entered as inventory, a unit on the ledger, counted, tracked, reconciled. Now you wait your arraignment or bail and a bailer to submit a bond as the surety, for your promise to pay, and promise to appear, as the bailee. Scene 5. The charge equals credit. They say you are charged with a crime. In law, that's accusation. In commerce, it's credit posted to an account. Credit on account. The prosecutor drafts the charging instrument. The judge charges the jury. Same word, same ledger. If not settled, it moves to the secretive grand jury for further proceedings and the market decides does the grand jury issue a true bill or no bill. A validated instrument or additioned instrument. Our bills have to be paid to stay in honor within our contracts. If we don't, bad things start to happen beyond our control. It is better to have been no billed than to have been billed at all. Scene 6. Pre-trial equals plea bargaining. Before trial begins, the bargaining starts in earnest. They call it pre-trial posturing, but it is a negotiation, a meeting of the minds, a time when bargaining takes on an entirely new meaning. The prosecutor says, I'm offering 10 years today. If you don't take the 10 today, it's 15 years next hearing. Take the deal. You'll be out on parole in a few years. 5, 10, 15, 25, or 60 years. Pressure, anxiety, and high stakes abound. That's settlement. Like creditors issuing loans, pay early, pay less. In this case, an adhesion contact most cannot afford. Avoid the cost of trial, punishments, and penalties by taking the deal. Scene 7. Grand jury equals bill or no bill. When the bargaining fails to reach an agreement, the grand jury begins deliberations within 120 days of the alleged offense. The prosecutor then proceeds to convince the grand jury of probable cause, and must prove enough evidence to proceed further with a trial by jury. The grand jury, having heard all testimony and evidence, must choose between indictment, or no indictment, or in commercial terms, presents either a true bill or a no bill. A bill is always commercial, a bill of exchange, a bill of lading, a dollar bill. Here, a bill of indictment, validated paper, or rejected paper. Either way, it's commerce and it's criminal. What takes place in the hallowed halls of justice? It's always about money. Scene 8. Trial equals marketplace of claims. The trial by jury is the marketplace. Evidence is tendered. Objections are reservations. Motions are applications. Having heard all the testimony and evidence, the judge charges the jury to find whether you are guilty beyond a reasonable doubt or not. Having found you guilty as charged, the judge then issues the warehouse receipt, your judgment and sentence, which meets all requirements pursuant to the Texas Business and Commerce Code Section 7.202, in which we will cover in detail later in the video. In finance, it fixes a debt. In criminal law, it fixes terms and condition, fines, fees, and penalties, but it's the same act. Obligation entered, inventory added to the financial institution. Just like a financial institution, Texas has institutions, prisons called the TDCJ Correctional Institutions Division. The accounting ledger now reflects your debt to society, complete with credits, debits, trustees, trust funds, and stored in a prison unit. Scene 9. Charge to the jury equals charge to the ledger. The judge says, "Ladies and gentlemen of the jury, I now charge you in law instruction. In commerce credit to the account." The jury now holds the ledger and they reconcile the ledger by the jury for person endorsing the charge to the jury and presenting it to the judge for issuance of the warehouse receipt. Scene 10. Sentence equals term of debt. The jury's verdict returned like an obligation. Another presentment seeking an acceptance performance. Now, the black-robed neutral party, the judge, then admonishes you, stating you are a danger to the citizens of Harris County, Texas. Therefore, by the authority vested to me by the state of Texas Incorporated, you are sentenced to a term of not less than 60 years in the Texas Department of Criminal Justice Correctional Institutions Division. A term with conditions, state fines, court fees, and of course, the penalty. In law, a sentence; in commerce, the maturity of a debt. 60 years, a 60-year obligation to maturity. You are the collateral pledged for the 60-year term. Scene 11. Remand equals transfer of collateral. Then the words that seal it. The defendant is remanded to the custody of the sheriff. Collateral transferred. The sheriff delivers the goods from county jail to TDCJCID, from one warehouse division to another. Here is Section 7.202 of the Texas Business and Commerce Code that state the exact 9 requirements of a warehouse receipt in Texas, and is 7-202 in the Uniform Commercial Code. The title: Form of Warehouse Receipt. A warehouse receipt need not be in any particular form. B. Unless a warehouse receipt provides for each of the following, the warehouse is liable for damages caused to a person injured by its omission. Requirement number 1. The location of the warehouse facility where the goods are stored. Requirement for number 1. TDCJ Correctional Institutions Division. Requirement number 2. The date of issue of the receipt. Requirement for number 2. The date of the sentencing. Requirement number 3. The unique identification code of the receipt. Requirement for number 3, case or cause number. Requirement number 4, a statement whether the goods received will be delivered to the bearer, to a named person, or to a named person or its order. Requirement for number 4, defendant to be remanded to the custody of the sheriff. Requirement number 5, the rate of storage and handling charges. But if goods are stored under a field warehousing arrangement, a statement of that fact is sufficient on a non-negotiable receipt. Requirement for number 5, court fees, fines, penalties, and other credits, debits, terms, and conditions. Requirement number 6, a description of the goods or the packages containing them. Requirement for number 6, your name, date of birth, race, and gender. Requirement number 7, the signature of the warehouse or its agent. Requirement for number 7, the judge representing the state of Texas Incorporated. Requirement number 8, if the receipt is issued for goods that the warehouse owns, either solely, jointly, or in common with others, the fact of that ownership. Requirement for number 8, custodianship via remand to the sheriff to TDCJC. Requirement number 9, a statement of the amount of advances made and of liabilities incurred for which the warehouse claims a lien or security interest. But if the precise amount of advances made, or of liabilities incurred is at the time of the issue of the receipt unknown to the warehouse, or to its agent that issued the receipt, a statement of the fact that advances have been made, or liabilities incurred, and the purpose of the advances, or liabilities is sufficient. Requirement for number 9, this would include days spent in jail, or credits of incarceration prior to sentencing. C. A warehouse may insert in its receipt any terms that are not contrary to this title and do not impair its obligation of delivery under Section 7.403 obligation of warehouse or carrier to deliver excuse or its duty of care under Section 7.204 duty of care contractual limitation of warehouse's liability. Any contrary provisions are ineffective. Until you see this side-by-side comparison of the judgment and sentence and the 9 requirements of Texas Business and Commerce Code Sector 7.202, you would never believe you have been warehoused by your state, with secret backdoor accounting, the 60-year bond, or promise to pay the state's monetary debts, and substantiate the for-profit corporate status of the judiciary courts of the state of Texas Incorporated. The subsidiary of the state of Texas Incorporated. Scene 12. Judgment and sentence equals warehouse receipt. The paperwork is called judgment and sentence. But in truth, it is a warehouse receipt. It names the item. It lists the charges. It sets the term. In commerce, a warehouse receipt certifies goods for storage. In criminal law, it certifies a person for custody, subject to charges until discharge. Scene 13. Prison equals warehouse. Count time equal inventory. And now you are stored in the vast prison warehouse. Once called Texas State Farms, now the TDCJ State Jail Units, Correctional Institutions Divisional Units. All units, commercial accounting, units categorized in divisions. Inside, the ritual, count time. Why do the correctional officers count the incarcerated offenders 12, 16, or 24 times a day? It's not just for security. It is inventory control. Accounting people as stock. You are the inventory. Stock reconciled. Scene 14. Trustees and trust fund accounts inside. Offenders become state-approved trustees. The word is fiduciary. Every Texas offender has a trust fund account. Deposits, withdrawals, balances, commissary, and outside third-party purchases through escrow. One trust established and operating for your time credited, and another trust for your funds. The warden, your ward of wards. Scene 15. Credits and debits equals time. Ledger time itself becomes accounting. Every day served is a debit. Good time. Work time. education time, or bonus time, all credits. Misconduct. Disciplinary case. You get a chargeback, loss of privileges, loss of good time, loss of trustee status, or move to a more secured location to protect the inventory or the wardens of the wards. U. The prisoner's timesheet is a bank statement. Debits, credits, balance due. Scene 16. Parole and probation equals conditional credit. Parole or probation. Conditional credit extensions. Freedom on terms. The commodity. You are transferred from one division to another until the full term reaches maturity, 60 years. Covenants enforced. Break the covenant. Credit revoked. In finance, that's acceleration. In corrections, revocation. Same law, same teeth. Scene 17. Discharge equals release of debt. And finally, the word that closes the account, discharge. In bankruptcy, a debt is discharged. In prison, a sentence is discharged. Same word, same act, ledger closed, balance, now zero. I have paid my debt to society. Not a metaphor, just more bookkeeping of the parasitic juvenile delinquent bully called the State of Texas Incorporated, a for-profit corporation using slave labor by trafficking humans between persons, the county jail, to TDCJ State Jail, or TDCJ CID, and maybe to TDCJ Parole Division. In reality, our governments are not any more ethical or moral than the criminals that buy, sell, and trade humans for profit. Scene 18. Closing. The circus from complaint to discharge, from accusation to warehouse, from charge to credit, from term to maturity, from judgment to warehouse receipt. Every word is commercial. Every step is a transaction. The judge, the prosecutor, the defense attorney. All bar members, all employed and paid by the same entity, the County of Harris, Texas, except your retained counsel, unless you get a court-appointed ultrabozo the clown. And you are the collateral. This isn't justice. It's commerce. The only question left. To bill or to no bill? That is today's $25,000 question. The three-ring circus called the judicial system is clearly structured to win at any cost through misconduct, lies, misstating law, suppressing exculpatory evidence or testimony. There are three rings. The judge in one, the prosecutor in another, and finally, Bozo, the clown, the hired gun you retain to defend you because you're mentally incompetent to handle your legal affairs. These court jesters act out this elaborate charade presenting truths, lies, and misdirection before a jury of your peers, but not really your peers. And you watch the elaborate performances with great expectations your hired gun will prevail. The only issue with that picture: your hired gun has an allegiance to the state bar and not to you, the client. Thank you for watching. And if you enjoyed the topic and education, please be sure to like this video, subscribe to the channel, and toggle the notification bell for new content. Leave a comment below about your experiences, legal remedies, or something missed in this video or can improve upon.
Thank you for hanging around after the show. I want to present to you me. I'm back. I saved you. You didn't have to listen to the outro. So there you go. Tell me what you think about that. Whether I should continue with that type of format, covering, anything and everything, or I come on here and do what I do, or just do pre-records and put them in the can and upload them and let y'all have fun with them later. This is what happened. Okay. Everybody's familiar with Mothers Against Drunk Driving. And God bless them. Okay. I have nothing against them, what they've done, what they're doing. They're doing a good thing, keeping repeat drunk drivers or any drunk drivers off the roads. So that I applaud. No problem with that. But it was established in Fort Worth, Texas, just north of me here from Houston. And back in the late 90s and early 2000s, there was a big uproar, continued lobbying by Mothers Against Drunk Driving with Texas legislatures to change the law so repeat DWI offenders weren't just getting a slap on the wrist, spending a night in jail, getting 6, 7, 8, 9, 10 DWIs, and finally getting probation, that kind of thing. Well, because of my moronic, I can't even say misspent youth, because it was missed opportunity youth. I'll say it that way. But I was a moron, a total idiot, drug addict, alcoholic before I even graduated high school. I was one of my people that I graduated with. His older brother is a retired HPD motorcycle cop, and I didn't get a chance to talk to him at the funeral that I went to Saturday. It's right around the corner. But he called me because I signed the book. He's like, "Hey, man, I didn't see you. Wish you were there. Blah, 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 blah." He ended up marrying the girl across the street from me. And they obviously they don't have a clue. But to get back to the whole Mothers Against Drunk Driving, I forget where I was going that with Randall. But they decided they wanted to continue to change the laws. So the DWI, driving while intoxicated statute, used to be, prior to September 1st, 1994, was in the Texas Transportation Code under Section 6701L. That's a little L. So our now mayor, Senator, he was a Senator Whitmire, Texas legislature, he rewrote the whole penal code. September 1st, 94, they incorporated it into the penal code. So they were getting a lot of slack towards the late 1990s and early 2000s. So the legislature went in and amended it, that particular subdivision of a section, which is 4909 in the Texas Penal Code. That's for repeat DWIs. I'm guilty. That's sin. That's why I don't drink. Don't ever want to drink. They amended the statute. And the reason they amended it is because they wanted to change the elements of the offense so it would have a wider jurisdiction to capture more repeat DWI offenders. So they amended it September 1st, 2001, September 1st, 2003, and amended it again in September 1st, 2005. And I have a printout of all the amendments they've actually done to that subdivision. I think it's in the other room. Since 1994, they've missed 4 legislative sessions, and Texas legislature meets every 2 years. And we missed 4 from monkeying with that. So they've changed the elements, and this is what happened. Most people don't even know this, and I have the book out in the garage. I don't have my bookshelves anymore. But the Texas has an association called the Texas County and District Attorneys Association. They publish basically the manuals, something similar to these books. I've had them before. I got them in prison. I have that code of criminal procedure out in the garage, but I used to have a penal code. So this is the manual that they use. They cite all the new recent case law that goes with the statute, whether it's a good or bad law. And not in my copies, but in their copies, they have the templates. So if you want to write a charging instrument, a complaint, or an indictment for a third-degree felony, it had the template in here. Well, the person who drafted that original template in September 1st, 1994, didn't plead all the elements of a third-degree felony DWI required by the Supreme Court of the United States of America, where it doesn't matter what kind of element it is. If it's a jurisdictional element, it must be proved, it must be alleged in the indictment, and the jury charge must be proven in the case in chief. That's the first half of the bifurcated trial, because you have the trial by jury and then you have the sentencing phase. I know I don't know anything. I'm just some retarded moron in my living room. So they went in and they kept changing those specific elements of the offense so they can catch more repeat DWI offenders. So every time they change that element, guess what? The template's supposed to change as well. But what they did is how the statute read for my offense, which would be prior to September 1st, 2001, because my offense was July 10th, 2001. So I'm in that gap between 94 and 2001. How mine read is you had to be twice previously convicted of any DWI, whether it's a misdemeanor or a felony. Okay. Now, for them to be able to use those two prior convictions, one of those DWIs, your prior DWIs, okay, the one you're being charged with now, I'm going to call that your primary DWI, your third, okay? Could be your 10th, but for this case, the third. So what they did is from the date of your offense, July 10th, 2001, you look back 10 years. If you committed a DWI within 10 years of your primary DWI, then the conviction for that DWI, as well as a conviction for any other DWI, doesn't matter how remote, which it could be 50 years ago, they can use it. So the element of the offense, the trigger element, is the commission date of that intervening prior DWI to effectuate the 10-year rule. It was committed within 10 years. Boom, you can go get any of the other two. So that commission date must be alleged in the complaint, in the indictment, charged to the jury, proven to the trier of fact, whether it's a jury or a judge, beyond a reasonable doubt. And when I was playing with Grok and Chat GPT, okay, because I was doing a parallel, that's what I always do, find out which one's the best one. And I have a paid subscription to Chat GPT 5.0. So in 2001, September 1st, they amended it, okay? And they changed that. And they added a capital A, a capital B, and a capital C. And I'm paraphrasing, I don't remember which one's which, but basically it was the day you got out of jail, the day you got out of prison, or the day you got your probation discharged, which we just covered in the video, okay? Then September 1st, 2003, they added capital D. So there were four, they changed them. And that one was like the day you got out of, got off parole or out of prison or something like that. So there were four different elements that they included. So now, okay, what has happened is they've changed it, and they didn't update their manual with the elements that should be alleged and proven beyond a reasonable doubt. They just said, okay, you just got to plead 2 prior convictions and that's a wrap. Okay. And we're just going to prove that. And that's a wrap. Who cares about when it was committed? Who cares about the day you got out of jail or day you got off probation or day you got out of prison or whatever? Okay. Those elements just, they don't count. No. So that's what they've done. Now, what's up, Floyd? How is that so? How is that just so grandiose? Well, I'll explain it to you. What that means is every felony DWI conviction, because everybody on the WIN unit who had any kind of alcohol-related offense, they came to me. I was the expert. I don't have a book here, but yeah. and I am. Absolutely. And I read dozens of DWIs, dozens of trial transcripts of DWIs and intoxication manslaughters. To this day, not once in that 25-year period, because we're approaching 25 years, have I ever read one DWI indictment that was pled correctly from September 1st, 1994 to August 31st, 2005, which means every one of those convictions, spaghetti-o, kind of screwed up. Well, had I been in prison, I would have never had access to the information that I have now. Had I not had AI, I would have never gotten the information that I have now. The only reason that I even got this information is because I had an ideation that somewhere, somebody drew up a template and that's what everybody followed, word for word, and nobody questioned it. And not only did nobody question it, nobody had the honor, integrity, good faith, and clean hands to correct it. To say, oh, we're doing it wrong. Hold on. We need to change the game up here. Absolutely. So at the time that I did my due diligence and research, when I was incarcerated, when I was actually chasing my conviction through a different animal called the Texas Health and Safety Code, which is they changed behind me, and you're going to know why here in a second, because at that time, I went and got the statistics from TDCJ, the system that I was in. How many offenders came in that have chemical dependency treatment when they came into prison or the day they got their offense? 70%. So what the vehicle was I using? I was using the writ of habeas corpus for emergency protective custody for chemical dependency treatment under the Texas Health and Safety Code. Because the only way you can get chemical dependency treatment in the Texas prison is if once you are granted parole and assigned by the Texas Board of Pardons and Paroles. So if you're doing an aggravated 15-year sentence, you're going to languish there for 7.5 years without any treatment. Nobody's even going to talk to you about treatment. You can go to AA all you want, but you're not going to go through a program. Absolutely not. Only upon granting of parole, then will you be put in a program. Wow. So how many offenders in the state of Texas, in the penal system, would have had remedy through that legal vehicle had I prevailed, had the Travis County attorney not lied and been disingenuous with the court and file bullshit with the court? 70,000 plus offenders would have had the same access I did, which means all the counties would be flooded with inmates trying to get a bench warrant back to their county of conviction for chemical dependency treatment by who? The county. You can see where that would run into a logistical and financial problem. So how do we fix that? Well, we go change the law, and then while the case is pending, we're just going to cite the new law and just forget he was filed under the old law. And we're going to run with that. And that's what they did. That's why I said they changed state law behind me. Absolutely. That's why. So what are they going to do with my case? Now, for those of you who don't know, I originally filed this writ back in, 04. They sat on it for 18 months here in Harris County. They would not forward it to Court of Criminal Appeals. When it finally did get sent there after probably a dozen mandamuses to the Court of Appeals to get relief, Finally, I even had to sue my judge and the clerk. And they still weren't trying to hear it. But once it finally did get there, and they actually did look at my exceptional brief that was thicker than that and my application, they issued a remand order for my trial court to hold an evidentiary hearing to find facts, conclude law about my claim of ineffective assistance of counsel. My trial counsel now disbarred J.T. Wilhite under Strickland versus Washington, which holds a two-pronged standard. Two-pronged standard is, had your attorney done something or not done something? And for an example, had my attorney went over there and talked to this alibi witness who I was banging all night long, just would not get out from between her legs because she was so gorgeous. He didn't go talk to her, and boom, the victim says I was there robbing 7-Eleven. That the outcome of the trial would have been different had my alibi witness come said, oh, he was making sweet love to me all night long. No way he could have been there. He can't be in two places at one time because he was in me. Right? So, where we're at with that is when my Republican judge, Mark Kent Ellis, who got voted out of office, he didn't want to hold the hearing. So 120 days, I'm still sitting in Huntsville going, why ain't I in Harris County? I want my hearing. I need to have my hearing. I've got a lot of things I need to say that I know I've been screwed over, been jacked with. You know, when the DA, when you have to force your trial attorney, hey, you need to object. Object to what? This guy's testifying to something. I don't even know what the hell he's talking about. He's talking about all degrees this, degrees that. I don't know what he's talking about. Object. Object. On what basis, Mr. Wilhite? My client says that he never took these tests. What's the DA say? Well, Your Honor, if Mr. Wilhite would have looked in the state's file, because they have an open file policy, he would have known that this officer would have had testimony of this nature, and he didn't do his job. She said that in open court. Absolutely, it's in the record. I mean, I just can't make this shit up. It was just, you know, in the video, I talk about, you know, you have high expectations of your hired gun because they may have a, you know, a reputation as a gunslinger and they're a category. We'll just say DWIs. And I did that at the very beginning. I did have one of the best DWI attorneys, except, damn it, that thing happened on September 11th, 2001 called 9/11. So as you know, all the money froze. Well, my money froze too. So I ended up losing that attorney, got J.T. Wilhite, and the nightmare is foretold. That if you know, and I went and sat in on one of his little misdemeanor DWI trials, and I was like, oh my God, this guy sucks. I'm going to go to trial with this guy, 25 to 99 or life, really? Oh man, I got to go find somebody else. And so the last 2 weeks, it was a scramble. I had no idea this dude's strung out on cocaine. He's using all the money I'm giving him to party. Man, he just got back from Acapulco. And man, yeah, I had no idea. So I got so upset that he literally came to the car lot I was working at, and I showed him a picture of my then 2-year-old daughter. Yeah, 2-year-old. She's probably almost 3. And said, bro, listen, okay, I can go do the time. She can't. She needs me. So you need to tell me right now, okay, while I still have time, can you handle this case? Because this is probably the biggest case you've ever tried. It's 25 to 99 or life. That's it, bro. If we lose, it's 25. Ain't no going under that. State asked for 35. Judge gave me 60. Ooh, bingo. It was so cool having that class in there on a field trip that day, right? So we can make an example out of Floyd Tarvin. Kids, don't drive drunk. This is the ramifications of you driving drunk. You're going to get 60 years in prison. Absolutely. So I put my faith in this dude. I thought he was going to get in there and get down, do the right thing, and got railroaded. Sat in county jail for 3 months waiting on sentencing, and, you know, kind of went to the law library a little bit here and there, and just, you know, I was just fucking shocked. I couldn't believe this had happened to me. Couldn't believe they had me locked up for this, for refusing all sobriety tests, refusing the breath test, on video saying I refuse to participate in any motor skills tests, only advice of my attorney. Who's your attorney, Mr. Tarvin? Larry Longer. And then after a scene, transportation for arrest, transportation to central intox, I'm on video, blah, blah, not going to do any tests. And then we leave the video room and I finally break down and decide I want to take a horizontal gaze nystagmus test. If you don't know what that is, that's they shine light in your eyes. So, you know, listen, it's probably 2, 3 in the morning. I've been busting my ass all day. I just went right, literally less than a mile from my house to go have some drinks with my buddy. Got pulled over driving home. So, all right, my boy's 10 minutes away. So I put all my faith in my hired gun, my gunslinger, to go in there and get down for me and do what he's supposed to do. And then I get to prison. And then I have to make a decision. You got 60 years, bro. You're going to do 7+ to go even talk to anybody about parole. So you're going to be here for 7 years. Flat. No way you're going home. Unless you go fight it. Or, you could hope for the best. Let the whole proceedings play out as they may, your appeals and all that stuff. And I can go get a master's degree on the state, on the government dime with the Pell Grant and all that. And I decided I was going to go litigate. And partly what pushed me, because probably the day I got locked up, my wife went and hooked up with somebody else. So she bailed on me right off the bat. And I was like, nobody to support me. Nobody send me money. I didn't want anybody to send me money. Told everybody, don't send me a freaking dime. Okay. I got here on my own. I'm going to take care of myself. I'm a man. And that's what I did. I went and got educated in the law library, and that was my hustle. I was a writ writer, a jailhouse lawyer. That's where I got my education. There was nobody, I wasn't getting any tutorials. I couldn't go on YouTube and watch some video or take some class. I had to learn everything. I had to go pull a book off the shelf and learn. I had to read, and continue to read until I was reading everything 3 or 4 times. And finally, everything went, oh, I see how this whole thing works now. Took me a while. So what we have here is a real big problem for the state. And I don't know how they're going to react to this. Now I have a Democratic liberal judge presiding in my court. I don't know how she's going to look at it. Like, oh, hey, I can overturn a Republican's case. I can make him look bad, make me look better. Getting down for, how they are with criminals now. We're all victims because we've been criminalized. So please have mercy upon my soul. But it still has to go to the Court of Criminal Appeals, and they can either, my court can recommend, lesser included offense, acquittal, retrial, whatever, send it up to the Court of Criminal Appeals just as a recommendation. Then they have to determine and do what they want to do and send it back. So when I complained after that 120 days under Code of Criminal Procedure, Article 11, I believe it's .51, if I remember correctly, That is the section that deals with, actually subsection that deals, or sub-article that deals with people who fail to obey the writ of habeas corpus. And what that is anybody who disobeys a writ or an order regarding the writ, okay, that's what we're dealing with. A capias, an arrest warrant, must be issued by the Court of Criminal Appeals for any peace officer in the state of Texas to arrest the person disobeying the writ of habeas corpus and bring them before the court to answer why they're disobeying the writ of habeas corpus. So the all-Republican Texas Court of Criminal Appeals really didn't like me putting a Republican judge whose father was a Republican judge on the hot seat. So, graciously enough, I guess, the staff counsel for the Court of Criminal Appeals dismissed my writ of habeas corpus, which means I get to refile at my leisure. So I've just been sitting on it, and I haven't filed it because I got to the point in prison where, again, I don't care what I threw at them, they were not going to let me win. They were going to suppress me every which way they could, legally, unlegally, illegally, lawful, unlawful, moral, immoral, unethical, ethical. I mean, yeah, those people are crazy. And that's what we're up against. I just got off the phone with somebody who's going through that experience, being caught up in the court system. And, I had to tell them, I don't think they really knew my background. And I told them, I know what it means to sit on that front line with your head in the guillotine and some psycho over there on the rope just going, tell me when, just waiting to chop your head off. And it's terrifying. Terrifying. You're going to lose your wife, your life. I lost everything I owned. My daughter, when she was 3, didn't see her again until she was 17. Talked to her maybe 3 or 4 times during that time on the phone for 5 minutes. Not one visit. And this isn't a pity party by any stretch of imagination. I did this to myself, okay? I'm the one who left my house and went and fucked up, and rest is history. So I don't lay blame to anybody. It is what it is. I call myself a failed father, which really sucks to say, but, I failed. Thank God she turned out the way she turned out. I mean, I couldn't be more thrilled with my daughter. If I could say that's what I want her to be, that's who she was. That's who she is. So she's an incredible young woman in her own right, not even if she was my daughter. I will keep fighting. Now, let me explain to you something about ChatGPT, because Anne, God bless her, Anne went and got her little subscription, I think, a couple days ago for ChatGPT. And she's like, Floyd, blah, 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 all the stuff that I've been going through with it. So it was so funny to, listen to her catch up to where I passed a long time ago. But now you have to feed it information. So had I not had ChatGPT, I would have never, ever, ever been able to access their original templates that they produced for their book. Absolutely. But I had to go tell ChatGPT the whole narrative. Hey, this is the deal. Just like I explained to you. Boom, I had to program all that in, and it went, boom. Oh, you know what? You're right. Here's the materials. And you are so correct, because it is not pled correctly. It is pled insufficiently with just the 2 prior convictions. And they ran with that. And I would have never found it without artificial intelligence. had I been still aggressive, pissed off, in a rage in prison, and just came right back with my second writ habeas corpus, not using reason and logic, but using passion and rage. That's why it's very difficult for people to do legal work, because they put their own passion and their feelings in it. And that's and I'm guilty. Okay. I'm guilty. That's how I got the name Fearless Floyd, because I used to, I call the warden out, call the assistant warden, building captain, major, lieutenant, sergeant. I didn't give a rat's ass. I had nothing left to lose. Nobody cared about me. All my friends had abandoned me. Nobody was writing me. Nobody was coming to visit. Obviously, I told everybody, don't send me money, but yeah. And when you have nothing to lose, I don't have a relationship with my daughter, so that's a wash. It's whatever. Come on. Let's go. Just like I'm the last man standing in the day room. They want to do a riot over the TVs. I don't even watch TV. I just want to have fun. So, hey, let's create a disturbance. And these hoes left me in the day room. I'm the last one going, you some sorry hoe ass. Yeah. Cussing them out all the way back to myself. Last one. I can't even begin to tell you all the stories. It's just insane. So I tell everybody, listen, if you're going to go litigate, don't bring foreign instruments into the game, which means don't bring all that sovereign citizen bullshit. Okay. Keep your papers clean. It should look just like their paperwork, because if you got a flag on it, guess what they're going to see? A flag. What's that flag mean? Oh, that's a sovereign citizen. So whenever you put any of that on there, and they've seen it before, and that may not even be your intent, they're going to categorize you just because that's what they were told. And it is what it is. So, yep, I'm going back. I'm not stopping. Actually, I was supposed to go get my appellate record today, but it was he got caught up and I wasn't able to get it. But I'll be at Jones Hall tomorrow anyway, so I'll just be right across the street, and I'm going to go pick up the CD-ROMs. I'm glad I got a CD player. You have to actually buy an external CD player now if you want to use a CD or a DVD. I gotta have one. So next up is the Court of Criminal Appeals. I've emailed them and left a message, and also I'm waiting on open records from the Houston Police Department, because my arresting officer, can't make this up, my arresting officer got fired, not even for doing what he did, which notoriously he pulled over this young lady in the same area. And hang on a second. Yes, sir. Okay. God, I hate getting interrupted, lose my train of thought. Hang on, I'll be right back. Here I am, back. Christopher Green. Christopher Green and George Miller, they pulled over this young lady on suspicion of driving while intoxicated, and somehow they got a hold of her device, whether it was a phone or a pad or whatever, and oh, look, she's got nude photos, George. Let's download these. Don't tell her nothing. Then later in court, he's going around showing all the court personnel, hey, and got popped. And eventually got terminated. However, he has now joined another law enforcement agency here locally. And from my background check, it looks like homeboy learned his lesson and has appearance that his continued learning education excelled after he was terminated from the Houston Police Department. So for that, accolades where accolades are due. I don't have any problem with that. Okay. I don't have a problem with cops at all. Actually, I told you I was talking to one yesterday on the phone. And they were talking about our old buddy Ray Hunt, who's the executive director at the Houston Policemen Patrolmen's Union. Like, yeah, you talked to Ray lately? We all went to school together. I was like, no, I haven't seen Ray in a minute. So, all right. I've got somebody coming over. I'm going to roll. I want to thank you all for being here and appreciate you. I don't know when I'll do another one. We're lining up part 20 for Ann LaFleur, so stay tuned for that. I will also have Derek Phillips. And if you're not familiar with Derek Phillips, his brother Lance Phillips and their mother, who works for Smith County, Lance and their mother, and I can't remember their mother's name. They're not only suing Smith County, but they were both arrested, and she has to make a determination on a plea bargain deal. Lance is under a gag order, so he can't speak. And I'm going to have Derek on. We're going to talk about that case and a bunch of other stuff. And I ran into Tawana Downing via Lance and Derek, and I had Tawana on my show. So I believe that we are at the precipice at a time of stability and instability in the United States of America, where a core group of people need to make a fundamental decision about the direction of this country, whether we continue to want to go through the political machinations or we want to stay divided in all these different assemblies and groups and associations, whatever. Okay. There has to be some leaders. There have to be some people that can go, you know what? I got to put my greed and my ego out of this picture. And that's the problem. So most of these people have greed and ego. You know, they got in this on, with good intentions, and then, then came the fame, then came the money, and then came the power, and, now it's their main driver, and they pretty much don't give a crap what they push or what they say, as long as that money and power continue to roll. So I'm above and beyond all that. I've already done all that crap. So I'm not trying to be famous. Like I said, I don't care whether I got 1 or 1 million viewers. It's not going to change my life, period. Okay. Nobody's going to come over here and back up Brink's armored truck to my garage and go, hey, Floyd, your payday's here. God, I wish. So, is what it is. Don't forget, we're going to put these together in booklets, individual trusts. You'll be able to pick those up on the fearlessfloydshow.com website. If you want to reach me, fearlessfloydshow@yahoo.com. If you want to call me, you all know my phone number. You can find it at the bottom of my homepage at thefearlessfloydshow.com. Appreciate you being here. Thank you, everybody. I did not do the outro, so outro coming up. If you want to bail now, you can hit that like, subscribe, share, hit that notification bell, and leave a comment below. I appreciate each and every one of you. Y'all have a good night. Got to go. Thank you for hanging around after the show. I want to present to you Tailor Made Trust, featuring Ann LaFleur's Trust Series, available at tailormadetrust.com. as well as the fearlessfloydshow.com store. Here are a handful of the available trusts that can be built, custom tailored to your needs and desires. 25 different trusts, plus the DNA trust addendum. And as always, Ann LaFleur's classic trusts and ancillary classes, and also Ann's books on trust and specialty trust, which I also co-authored. If you'd like to get a class, a book, or have a trust custom built for you, always available at the fearlessfloydshow.com store. And I'll see you in the next show. Thank you for watching and have an awesome day.